Thanks, Torre. And yeah, it's a really great pleasure to be here. Thank you, and Benjamin Cheng, even though he's, I think, traveling, but yeah, thanks him, please. And also Professor Scott Leach and Anthony. So I've just been to the eco-normativity workshop on social techno normativity for the past 2 days. Thank you for inviting me as well. And yeah, today, so my topic is about automated law enforcement. And the case study is social credit system, and specifically the blacklist that branch specifically on enforcing contract and debt. So my methodology is mainly interviews. I use doctrinal evidence and interview evidence. So let's start with some technology first. So even though a lot of the technology in social credit doesn't involve machine learning, it's good to have an idea of how like the new technology is advancing or what it's capable of. For example, last year, the reasoning model became a big thing. So from this graph, you can see that the O1 model, which claims to have reasoning power, has achieved much better benchmark in terms of mathematics, coding, and even PhD level science. OpenAI recently had a product. Sam Altman says, if you pay $2,000 per month, you can have an AI PhD doing research for you. He will spend 2 to 3 days, work on a report for you, which will be usually conducted for months by a PhD. So yeah, this is a very fast progressing field. And recently we'll also have seen DeepSeek from Hangzhou, which promulgated the open source models, which can be localized by each institutions and universities. So a lot of the scientists in Europe, we've seen recently, are very happy about open source models because you don't need that much computational power and has certain advantages over the large language model by big tech companies. But my question is, with all these kind of really almost aggressively powerful advancements in technology, where's the place of law in all this? Will computer science, replace law as a discipline itself? Can code replace law? From this classic debate from since Lessig in the 90s about code is law, but what if code becomes law entirely and encroaching on every aspect of law? For example, ChatGPT passed the US bar exam already in 2023, imagining it argue a case for you in the court. There are some legal startups being used in US courts, but banned by lawyers. Adjudication side, China's smart code has early experimentation since 2013. I've written about it in my paper, my chapter in 2023, a little bit on that. This paper I'm going to present today is mostly about enforcement, so a very specific process in law, which is not very usually discussed. When I see a lot of students here, you usually talk about doctrines, you want to be a lawyer, but do you really know how law is enforced? Have you actually gone to the court to see how a contract is enforced? So this is an interesting aspect I see from the social credit case study. So there are literatures about enforcement and automated enforcement. There's literature about social credit. I try to combine them both. So my case study is on this really emerging field of social credit. And my specific focus in this small paper is on the blacklist and joint sanction. It's very different from social scoring, which I will not talk a lot about today, but maybe in the Q&A. So scoring, so you probably heard about Sesame credit or local credit scores from government. But the very big branch that started earlier in the social credit is this blacklist system. It's not a lot of machine learning. It's mostly just facial recognition, information sharing, and public infrastructure with digital technologies. The space-time is in urban Shanghai since 2013 when the social credit system first started. I conducted the interviews in 2021 and April. There's large part of social credit in the rural area, which is about 25% of China's population, which is more than the US population. I don't have the resource to do that part of the interview, so I do not discuss the rural part of the social credit here. Facial recognition, if you've been to mainland and travel by high-speed train, you'll be very used to this kind of cameras scanning. When you pass the gate, you have your ID scanned, but you also have your face scanned, just to double confirm. And that's the scoring I'm not going to talk about, but these facial recognitions, they can block you at the gate, but usually it's preventing you from buying the ticket itself already. You wouldn't come to go to the gate. But if you, for example, I use Tauray's ID to buy a ticket, but I'm a debtor, for example, I owe Tauray money and the judge asked me to pay him, but I didn't, then I will be on this blacklist. It's automatically shared to all these gates, and then they will block you from entering a high-speed train until you pay your debt. So my question is, can law enforcement be automated, or can it be almost like semi-automated, let's say? It's not fully automated, but at least at the terminals, you have all these kind of machines contributing to the enforcement of law. In the West, we have Google's own contract. So Zuboff, in this hypothetical scenario, talked about a mother being trapped in a blizzard on her car, driving a car to see her children in the hospital. But Google's smart car, self-driving car, stopped her because she ran out of money in her like in her digital wallet. The Google algorithm said you have to pay it, then you can go on to travel to the hospital. But in this situation, without any human interference, we can imagine a tragic situation happening. Well, this is a hypothetical scenario Zuboff used to illustrate the problem of automated enforcement of contract, for example. The state-led social credit system have a more kind of political side on the state being a more prominent role in enforcing law. So the big question is, like, can code, AI, or this kind of text or code-driven law replace text-driven law? There's some literature on that. This paper's specific question is on law enforcement. Very quickly on the English and Chinese literature on the social credit, there are a lot of empirical research. There are some theorizations trying to understand this new emergent phenomenon. But there's limits to this literature, and which is also why my paper tries to fill in the gap of, first, in the theoretical framing. I try not to give it a very big kind of like digital state or reputation state, this kind of framing. I want to look at the more detailed mechanisms of how things function, how law and code function in a specific case of law enforcement. But it's also a rather novel framing, I think. At least when I was writing it, it was not discussed very much in terms of social credit. And this very limited field-based interview evidence on what social credit actually is before this grand theorization. So I want to provide this empirical evidence before we go into discussing what it is like theoretically. Yeah, so framing, I propose the scaling and layering, which I discussed a lot yesterday at Scott's seminar, because it's a more like a legal theory and theoretical discussion. Today, I present more empirical evidence on the field-based interviews with a lot of doctrinal analysis and empirical analysis. I hope to provide a descriptive framework of governance, but it's a descriptive framework of normativities from our, as we discussed in the eco-normativity seminar, but it has normative implications. By providing this grounding using empirical evidence, policymaker, legislators, computer scientists can draw their own normative understanding or implications in their system design or legislation. So that's the main goal of this paper. But first, let's see, what do I mean by layering and scaling? Very quickly, I want to say that there are different modes of governance. When you think about when we interact in society, let's say social norms as a very important part of governing our behaviors. Let's say we go to a nice formal dinner and you have the knife cutting your steak, but we know that the knife is not used to stab each other, but for eating. That's the social norm. It can be purely behavior, nonverbal. We have laws which use abstractions of natural language to express certain social norms. Let's say we have crime, we have debt, we have contract, and what is honesty, what is justice. So these are high-level concepts, but also very concrete concepts like consideration or intentionality. And then there's numbers. There's the statistical kind of understanding of our material world. For example, we have the table here. It is material. We have a social understanding of what a table is. But then the law coded as a property, for example, of this university's property. And then it can go to the market. Let's say this table is encoded or quantified into a number, and it goes into the global financial market to be put into, let's say, a financial instrument. But the code in another layer put these numbers or data using machine learning or digital infrastructure using 0 and 1s as the most abstracted form. That's what I propose to say. It's like one of the further layer of governing our material world. That's the scaling, and there's the layering of it. It's between this each kind of layers of governance, they have interactions. They're in conflict with each other a lot of time. They can align with each other sometime precariously. Let's think about laws based on certain norms, let's say on gay marriage or on or an abortion. So there's conflicting social norms or political discussions. And then you have certain laws kind of trapping or locking in certain political agreement at certain time. But it's precariously aligned usually. The numbers and laws relationship I propose to have a similar and complementarity in itself and also between code and numbers. So there is a potential algorithmic turn from, let's say, the more concrete or less abstracted form of governance. So by magma, I mean the social practice. Let's say we are here forming a social practice of, giving a talk and discussing it. There are certain norms around it. And then there are kind of more higher level of law regarding boundaries or what is the information sharing. And there's the numbers and the code in each scenarios. And they expand in geographies and populations. When you think about how the rise of the modern capitalist society, we used to only have very close-knit personal trade. For example, in China, there's literature about informal institutions, how Guangxi in Wenzhou area helped it grow into a modern capitalist society using the contract law and property to form a larger national market of the Chinese market economy since the 1970s and 80s, and how this global kind of corporate law or financial law helped growing into the global market. For the Pistor's work and Supio's work about IMF and World Bank, the UN index and standards, how they actually use this kind of financial management to help coordinate global governance at a larger scale. And Zuboff wrote about information civilization, saying that now we are globalized, but we're all using more and more a digital infrastructure. There's kind of emergence of a new global information civilization out of that. What I'm trying to say, there's also the layering part of it. It's that the cognitive layering happens between the layers. For example, we have understanding of what Uber drivers are in our kind of interactions. But then the UK court decided that Uber is not an employee nor an independent contractor. They gave a third category of the workers to kind of encode this new social practice. And then the numbers, the statistical models of understanding employment will have to change because of this new category. And then let's say the tax algorithm that calculates your tax based on your employment status will change accordingly. That's what I mean by in cognitive layering. And in this cognitive layering, there's institutional class dependency. From institutional theories, we can see from informal to formal, let's say, a Supreme Court judgment on gay marriage or let's say company law will lock in certain values at certain time. But it can also reinforce or lock in certain negative feature. Gay marriage was not there, but criminalization has been there for a really long time. So you can have all these precariously aligned law and social norms or perfectly aligned, but actually not that well. After a while, you realize it's not really justice. Well, there's still debate about criminalization of gay, I guess, intimacy, of course. But so we can see that things are changing, but there are governance failures in the more systematic way in the sense with disregard of all the normative judgment on our social norms, there could be a collapse of this governance system when the misalignment happens and when the political or the social practice will break this multi-layered governance and create certain new social norms and rules. That's my proposal of this understanding of how a descriptive understanding of how governance is made in our modern world with the different modes of governance or normativities. Okay, now finally come to the more empirical side of the paper. This part I think will be very interesting for those wanting to understand China and also wanting to understand a case study, for example, the methodology. I'm very interested in this kind of empirical methodology. So Shanghai has 26 million population, about a third of the UK population. This is a picture. If you haven't been, highly recommend it. The Bund, not as beautiful as the Victoria Harbour. I went to see it the other day, but I think it's a great city. You should visit. But why I picked this empirical method? So, for example, Eleanor Ostrom, the Nobel Prize winner in economics, wrote about how rich information can be gathered from non-replicable data points by conducting in-depth interviews. That's why I did not use a lot of quantified data. And I want to discuss how social norms and code interact in real life. There's complex causation and causal links between agents, organizational networks, and behaviors. So we want to see law in practice from adjudication to enforcement. And I think interviews linked with doctrine is a very good method. So that's Ostrom, a very nice lady. Yeah, qualitative semi-structured interviews, snowballing method. So I get to know certain critical links in Shanghai, for example, a professor and then a government official, then they'll introduce me to other judges or officials there. It's mostly not recorded. Notes were typed almost verbatim. At the time, I just like talk to them, I write it down on my laptop, and then I translate it into English after the interviews. It's all face-to-face. At that time, I could still travel in Shanghai in April 2021. I had 15 interviews in 9 settings with total of 15 interviewees. That's part of my larger interview process in China. Why Shanghai? It has the longest social credit system since 1999, with the social credit law enforced in 2017. It's mostly about data sharing and data practices. The Yangtze Delta is also more mature economy comparable to, say, the more advanced economies in Europe and the US. So the courts there are also more or less more independent, transparent, and upholding rule of law. Of course, it's not perfect. We know a lot of literature about corruption, about influences of political things, but let's say it's more or less a comparable case in terms of the rule of law and understanding how code influence rule of law. Another picture of Shanghai. Okay, so this is a bit more technical in terms of how social credit function in a specific case. So imagining I owe money to Tao again, sorry. The court will ask me to pay back the debt. If I don't have money, then I couldn't do it. There are different reasons why. Some people hide their money by having, other places to store their money and did not let the government know. So you have the court's first instance, final judgment. If there's review decision, that's civil procedure law in China. If not, after the court made the decision, they will enforce the debt from try to get my money back to Tao Rei. And then the enforcement judges is in a specific division in the Chinese court. It's kind of a special arrangement, which is very different from a lot of other jurisdictions. Also, if you have arbitration cases, also goes to enforcement judges. In terms of administrative cases, the regulatory agencies make their administrative decisions with certain review procedures. It also goes to the enforcement officers, which is different from the court. So there are 2 types of enforcement procedure. Mainly, we can look at the court. The judges, they either put them into the blacklist or they start enforcing the case. For example, when I did my internship in one of the high court in China, the judges will tell me, today I went to this company, try to knock on their doors, see if there are people there. And, just to see if there are actual assets they still have. It's very time consuming. Chinese courts are usually lack of enforcement judges. People have all kinds of way of hiding their assets. But the enforcement also takes a long time. You can have opposition, you have reconsideration in Chinese civil law. But the much easier way after the blacklist, judges say is, well, if we don't have enough people, why don't we just put it on the blacklist and let the facial recognition help us enforce it? Then if I actually have money and I want to travel, then I would say, well, I don't care about this £1,000. I'll pay it back to Tao Rei, and then I can freely travel. So this goes to the human and/or machine enforcement for blacklist. I call it a difficult appeals downstream in the sense that once you're in the blacklist, it's much harder for you to get out of it. You have to prove certain things like you have paid your debt, and then make sure that the judgment notify the larger infrastructure that you've done it to get you out of this, to share with all the terminals. There are push notification and public shaming. These two mechanisms of this blacklist. I will discuss them more in detail later. And then after you're on the blacklist, you have the joint sanctions. It's the automated penalization, the one I talked about at the gates of airport or train stations. And other things include you can't have your children go to private school. You can't have expensive hotel holidays. Well, we don't know how they actually knew this. Well, there's certain privacy issues related to this, but they got this kind of multi-layered memorandum of understandings between local governments and agencies on how they enforce this. So it's a massive network of push notifications. This is the first mechanism. I call it push notification. Everybody has their phone. You have a lot of notification on your phone right now from WeChat, from WhatsApp. So that's what they do basically. Once they have a new data point in this database, they push notify all the government agencies. They push to every partner they have, telling them, I am on the blacklist. Don't let him go travel using high-speed train because if he has that money, he needs to pay it. The law regarding it was started in 2013 with amendment. It got a lot more kind of procedural protection since 2017, let's say. Penalization with different agents, let's say courts, railway, airline operators. They use basically code and ICT, very simple, just digital infrastructures, nothing related to AI or machine learning. But at the gate, you have this simple use of facial recognition to enforce this. The memorandum understandings made under laws and regulations, they link the authority, let's say the legality of certain regulatory agency and the court to the enforcement agency to kind of make it legal on the form at least. The legitimacy question we'll talk a bit later, which is the more kind of fun question, I think, as well. Okay, so the parts two I discussed. So now we have an understanding of how law is embedded in this kind of physical material world enforced by machines. The doctrines reveals how code-driven, kind of text-driven law shapes our reality, right? With code together. And now we have interview evidence. So they are all perceived gains and loss from the interviewees. There are three main kind of loss I will discuss more in detail. The gains are very kind of unanimous on the degrees of, scaling in terms of efficiency. Is that now it's much efficient to enforce contract and debt for a long time. So the first kind of adversity, or like I think the problem facing these judges almost and debtors is that the code has rigidity. This is a quote. So it's from I think one of the officials. So is that the SPC is the Supreme People's Court, so the highest court in China. Is that it's very rigid. Once you list someone on this blacklist, you then have to go all the way back to the Supreme Court to appeal certain times. It might not be best for a company's development because as you can foresee that when a company cannot have further loans, they wouldn't be able to build their business and repair their old loans. This is the case after COVID, especially after a lot of small and medium-sized business in China run out of cash. And the cash chain broke and then they couldn't run. And then the local government started saying, well, we don't really care about what the Supreme Court says anymore. We just want our local business to thrive. And then they said, we will take the initiative and guarantee that they can pay it back. So they kind of defy the Supreme Court's basically this digital infrastructure and say, we will keep these companies loans in some ways in negotiation with the central government and the court. Yeah, it happened in a lot of cases in different places in China after COVID. So this is a picture of, when you think of law, if it's like a square, it's kind of open interpretable. It can get into different shape. But a triangle is a very stable structure if you think of as the abstraction or the formalization of the artificial language of numbers. It's much harder to reinterpret certain things in this sense. That's why I call it the code's rigidity, faced with dynamic and non-ergodic reality. Okay, non-ergodic, it's more in kind of like a understanding of physical time or like irreversible time in terms of economies. There's literature in economics and math about how we understand social reality as it's irreversible. It's not a frequency-based probability based on Newtonian understanding of the world. It's related to the understanding of how social reality actually is and how code as a very rigid language might not be able to capture this very dynamic and non-ergodic reality of our world. The second one is more interesting. I think it's when the officials told me very unexpectedly, they were complaining about the judges, saying, well, we used all this money to train high-level civil service and judges to take all the bar exam, law school training. And now you have all these, machines doing their job. And then they start feeling like, oh, I don't need to, spend all my days knocking on doors to see if they have assets. Let's just leave it to the machines. Then the judges will stop using their skills. Well, not in a bad faith way, but, everybody have KPIs, how it feels to work until late night. And they just say, well, why not? We have all this backlog of cases, so the officials were complaining, say it's going to be lazy government. It's going to be, you have this, you need a granularization of institution in local government and courts, but now you use this very centralized kind of system. It doesn't necessarily provide this granularization. Well, judges are not like that, of course. They're very hardworking, but it's just an illustration of how it could happen, well, when code is doing a lot of things. The last one is the more interesting one. There's some officials telling me this, their hypothetical fear of legitimacy loss. They call it institutional overload. So imagine when judges all start being happy about putting people on the blacklist, what will happen? The thing is the database will keep growing, right? If you have a lot of incentives to put people into the blacklist without incentives of getting them out of the blacklist, then the database will keep growing and grow. And that's a very common thing we see from data infrastructure or data or AI related technologies. It's very self-referential. It's very self-reinforcing. If you don't have certain institutions like law to require judges say, let's say, if you have 2 people on the list today, you need to get 3 out, then they will not do it. There's no incentive for them to do it. Then the database will keep growing. There's a very interesting hypothetical number of 10%. The civil service said, what if 10% of the Shanghai population all got on this blacklist when the economy is really bad? Everybody's owing everybody money, right? What would they do? They would just start chatting with each other in WeChat groups saying, okay, you still haven't paid your debt today, but who cares? Let's, enjoy life still and leave. We just don't need to travel anymore in China. That's very similar to the Victorian, the debtors in England. They say like, well, if we all have this debt, let's just buy a house together in a distant place and live happily. We don't care about the debt. So that's the legitimacy question about what institutions can do at certain capacity from the social norms of justice, of contract, of debt, of what is good faith. They all like vessels of concepts that contain certain understanding of cognition. That's what I mean by layering of cognitions. And once you reach the top layer, it's very easy to lose certain grasp of this understanding at the basis in the reality of how people actually understand the law and interact with each other. So this is a problem of institutional capacity, a quote from one of the interviewees, saying that if too many people are in the blacklist, they will used to and start being deterred by the force of law in some sense. And also not just deterrence, but also the internal compliance, this social norms obeying the law, this authority feeling. Just to lighten up the mood a bit, it's a picture of a donkey being lifted by the things they're supposed to carry, right? If we imagine legal system as a capacity of a carriage leading us to somewhere, and the donkey is like judges and this IT infrastructure trying to carry us to enforce the law and enforce a capitalist understanding of contract in modern capital market, then if you have too many people or debtors and not in the economy anymore, it would just lift the system and suspend it, saying this is not working. And you become this ridiculous, silly situation when the donkey doesn't know what happened, but it's just in the air. That's what I think of institutional overload in kind of a funny way. And in the end, let's try to test my hypothesis or layering framework using this case study. Okay, I'll have spent maybe very quickly a few minutes. So there's this spatial layering effect, I call it, that you want more standardization, you want faster enforcement of law across space, but then when the appeal systems are centralized, then you make it very hard for local readjustment, right? So layering happens across space. When the local cognition is misaligned with the law or the code, it will have to adjust. So that's what I said. The Hangzhou core of the internet already in 2021 started giving guarantees to provide loans to these companies on the debtors list, and so that they can pay back that loan using new loans. Whether they in the end succeeded, I didn't know. But after 2022 and 23, I start seeing all the news after COVID. Local governments are all doing that. They basically start helping. They call it the instituting. It's not on this, but it's instituting credit. They help build their trust in these companies. There's the temporal layering part, which is more related to institutional overload. So through time, because social reality will change, then the judges and enforcers can be trapped in a kind of habit or inertia to put things into the database. They're maybe not very aware of it. And without the oversight or supervision from, let's say, the government or like senior judges looking at a database, look, each judge would just do their job. They would just perfectly fine, you know? But then it leads to a holistic or like on an overall institutional failure or the institutional failure. If you remember this picture of this magma breaking through the layers of governance, that's when the system breaks and fails, I think. So if you have social norms on, for example, honesty, dishonesty, that's just an example. There could be other concepts like contract debt, good faith. And then you have contract laws, this more fictional understanding of what a real contract is, or in a legal fiction sense, but it's a very real. And then you have data and numbers labeled names in blacklists and into quantified data. And then you have code infrastructure and software that automatically share information using facial recognition, verifying people, and physically make law real in the world by preventing transactions or preventing certain privileges. So that's the picture of what I see as the potential threat, or what I get from the perceived interviews, understanding of the threat of the credit system in Shanghai. So human agency is required, as I said, to refit. The refitting is kind of a computer science understanding of a representation trying to map onto social reality. So computer scientists think that there's a ground truth, and what the code do is to map what the ground truth is. However, it is not like that. Social reality, as I said, is more like a magma. It's like dynamic and irreversible. In irreversible time, it's not perfect. It's not ground truth. And automated enforcement, especially there's humanetic gaps and affordance of delay provided by our modern legal system to delay almost the time between a judgment and the enforcement, and creating all these buffering zones, the space between representation, understanding, and action is very important. And human interpretive capacity, like each of the lawyer here, you have to interpret a text and apply it to the situation in a concrete context. For example, an enforcement judge would not tell a mother to stop driving to see her daughter, for example, in a blizzard. That's outrageous. A local court can say, this is not good for our local economy. We don't need to follow this, right? There is this interpretive ambiguity that law affords to social reality. The slowness as a normative role in society might help promote the capacity or the running functioning of systems. Okay, so the conscious human choice at local level is very important. And through time, it's also important to remain the overall legitimacy of the system. So that's how it links to my hypothesis in terms of scaling and layering. So the conclusion, a quick recap. So automated enforcement will require human judgment combined with computation due to governance layer, basically the past dependency of code on law. the pitfalls, including rigidity, disempowerment, and overloads, they will cause the kind of the collapse or like breaking through, like the magma breaking through these layers of governance. And human agencies and societal feedback are crucial to continuously realign and refit between the systems of normativities or governance in specific spatial temporal environments. You don't expect them to understand this without the social, the input from the specific input from human observation and interaction and intervention sometimes. So code complements law and is layered on law. That's the catchphrase, if you want to remember from a paper, is that code cannot replace law because descriptively or like functionally, it relies on these normative layers beneath or interior to it. And it can only complement each other in a very complicated way. I cannot say that I've understood it fully, but I'm proposing this hypothesis. I hope there'll be more empirical work, testing it, tweaking with it to see how we can use it to explain more phenomenon and understanding of changing reality in law and AI and algorithm. Yeah, that's my presentation. Thank you very much. Looking forward to bombing me with your question.